Well, shall we hit the road then? Last week we were talking about dispute settlement methods. We have said that the use of international relations, discipline, the use of international law is maintaining peace, of course, because states can easily solve their problems by use of force, by making wars, and we have seen enough of wars actually in our history. The First World War and then the Second World War, that was enough. That was so bad. Therefore, in order to prevent such destructions happening once again, UN was established. What is the main mandate of United Nations? Why is that established? The basic aims of UN. They are protection and promotion of human rights and maintenance of international peace and security. So peace, security, and human rights are the most important elements of the United Nations. Therefore, we expect UN as an international organization and the entire international legal system that is completely shaped around the United Nations to promote human rights, to promote peace, to maintain security. How it does this? It does this, United Nations maintain peace and security through its organs, of course. It has 6 main organs and through them. Well, what is the relation between use of force and that? Use of force, not partial, almost completely prohibited by the new legal system. UN Charter prohibits use of force itself, plus it also prohibits threatening by use of force as a method of maintaining peace and security. Well, use of force partially has a role in domestic systems, but it does not actually exist in international law. Normally, it's prohibited. It is limited to Security Council. You already know that part. International law is mainly based upon consent and based upon reliance. So, reciprocity, good faith, amicable relations, friendly relations, that's the aim, and relations are shaped around this. And we have said that UN Charter strictly prohibits use of force, plus it also prohibits the threat of use of force. When one state threatens the other one by occupying it, by attacking this, this is also completely prohibited. In addition to UN Charter, we have another source in terms of use of force that's known as the Principles of International Law. That's a declaration, UN Declaration of 1970. According to this declaration as well, use of force is prohibited. Act of aggression is prohibited. Do you remember the definition of act of aggression from international criminal law? It was planning, organizing war, inspiring war, inciting war. States are also prohibited from threatening each other. States are also prohibited from taking revenge from each other. I'm using this word in order to facilitate your understanding. You cannot use the word revenge in the exam. The word you're using in the exam is going to be reprisal. Okay? Reprisal is not allowed in this system. And states also cannot use force in order to deprive right to self-determination of other nations. And also states cannot use force against independence of other states. Plus, states are expected to avoid from terror, supporting terrorist organizations, providing them with financial or other kinds of backing, and so on. what we understand from force is mainly military force, of course, armed force. You're already knowledgeable about use of force in international law. If I just started by asking you how use of force is in international law, I know that my students would have answered already by saying that use of force is prohibited by the UN Charter. Threatening other states by use of force is also prohibited. The only exception is self-defense. You would say this to me. And the only authorized organization to use force is Security Council. So this part is already clear to you. The thing is that you already know self-defense is allowed. So self-defense, when can that be used is the question. It can be used if a state is attacked by another one, right? Yeah, I agree with that. What kind of attack are we talking about? If the territorial integrity of the state is targeted, then the victim state can defend itself. So territorial integrity as target, that's unacceptable. Independence as target is unacceptable. Sovereignty as target is unacceptable. So use of force is prohibited when it is directed against the territorial integrity of another state, against independence of another state, against sovereignty of another state. This is the first element that you're supposed to keep in mind. There are different categories of force. For instance, retortion is a very prominent one. This is also use of force, but this one is not a military usage, and this one is completely legal and legitimate. What happens in retortion is that, perhaps I can provide you with one very recent example. If you remember the Turkish minister visiting Netherlands, that was a huge scandal in between Netherlands and Turkey. Turkish people were knifing oranges in the streets. That event, what I'm referring to. You remember? Okay. In that event, if you remember, what has happened was the minister has informed Netherlands that they are flying towards them. And Netherlands said, it is before your elections, therefore it is not okay that you land in. And therefore, Turkish minister has landed in Germany and has taken the highway towards Netherlands. And after she arrived in Netherlands, she wanted to enter into the council building. And what has happened is Dutch police blocking the entire street to prevent her from entering the building. That was the event, if you remember. In this event, we come across with severing in international relations in between Turkey and Netherlands. But we don't see any of the parties violating international law. The violation is against friendly relations. I want to come to your home and you say that this is not a correct moment, but then I hear that pizza guy is coming too, so I just appear with him, right? Like that. So nothing illegal there, but it is unfriendly. And what Dutch police has done, it is Dutch police, it is Dutch territory, it is Dutch street. So there is nothing illegal in that. But they're preventing her entering into council building. So this was the reprisal retortion actually, against her move not to land in Netherlands, but Germany and take a different path to enter into Netherlands. So everything is unfriendly in this event, but nothing is illegal. So Turkish side has made something unfriendly, and Dutch side has also, their reaction was also unfriendly, because they were trying to show a kind of reaction to what's happening. They were trying to reflect their displeasure with what's going on. Therefore, this is also known as a way of use of force, retortion. This is completely legitimate. This is completely legal, what's happening here. And we're not talking about any kind of military act. So that can be something economic, that can be political, that can be diplomatic. The reaction is given. And all of them are acceptable. Severing diplomatic ties is something that we often see, right? Downgrading the diplomatic relations, pulling the ambassador back and just leaving charge d'affaires instead of the ambassador. So this is downgrading. Restrictive control of aliens. Aliens do not mean, of course, extraterrestrial beings. Aliens are people coming from other lands, okay? So such a thing has happened in between United States and Turkey, if you remember, just slowing down the entire visa action. That has happened last year, if I'm not mistaken. How it was US visa sanctions have just slowed down their actions. So as a Turkish citizen, when you visit the embassy consulate saying that in May, I'm going to have a conference in the United States, therefore I'm applying for visa, what visa section was doing is giving you then an appointment for June or July. Well, this is something completely legal, but this is something unfriendly. And Turkish side has also reacted in a similar way. This is what is meant by that. So we come across with such kind of reactions a lot in international relations. And this is completely legal, legitimate, and this is just kind of reaction, displeasant reaction. If we come to reprisals, reprisal is, actually you have already studied states' responsibilities under international law. So imagine Syrian state damages a dam in Turkey. As a student of international law, at the moment you know that Turkey should not damage a hospital in Syria back, but what Turkey should do is starting a case against Syria saying that you have damaged us and this is an act of tort. Therefore, we expect, and this act is attributable to the state because one of your agents have done it. Therefore, we expect apologies. What else? We expect compensation, reparations, and improvement of the situation. If the injured state takes actions that are not in line with state responsibility law and takes revenge, then this is known as reprisal, and reprisal is completely prohibited in international law. We have said that retortion is legal, legitimate, unfriendly. Retortion is illegal, illegitimate, and it incites wars. This is actually why we have... Which part? I don't remember what I've just said. We have said that retortion is legal and legitimate. Reprisal is something like taking revenge. States are expected to employ the regulations and laws of state responsibility under such conditions instead of taking revenge, instead of going for reprisals. Because reprisals incite war. States start to punish each other by reprisals. And this is something unwanted in international relations. We have said that the main aim of international law and international relations is establishing friendly ties in between states, increasing interdependence, so that decreasing the possibility of war. And this system, reprisals, are giving harm to that system. Therefore, instead of reprisal, we expect states employing which law? No one was listening. State responsibility. This will be perhaps a quiz question. Now everybody's sleeping. Why not to use it? And self-defense is the third category of international, use of force. As you know, self-defense is a right. This right is already acknowledged by the UN Charter in Article 51. So this is an inherent right, and no one can take this right away from the states. The question is, when is it self-defense and when is it not? So the elements that you're supposed to find in self-defense are if territorial integrity of the state is targeted, if sovereignty of the state is targeted, if independence of the state is targeted. So the state becomes a victim. The state is attacked by military means, and that attack is against its territorial integrity, against its independence, against its sovereignty. Then the victim state is completely allowed to take immediate military action against this kind of a move. Then it is known as self-defense. Do you have questions until this part? Let's start from... Okay, Sinan. Okay, fine.
What's the extent of the right to self-defense? Okay, a state takes military action against the invader, but like, can it go beyond its borders and then capture the capital of the aggression state?
Proportionality is the case. The answer, the reaction must be proportionate. So there is an action against territorial integrity of state A. State A can oust the attackers by certain military actions, but if that state suddenly decides to use its nuclear weapons, then we ask, was that proportionate? And proportionality is measured through the damage. Damage that is caused or that may be caused. That's where we're concentrating on. Yes, please.
You said if Syria bombs hospital in Turkey, it's state responsibility. But if they invade the hospital, then can we talk about that?
You have to tell me if that invasion is for one of those reasons. I mean, if the hospital is in Turkey, then it is also an action against territorial integrity of Turkish state. Then, yes. So those are the key elements that you're supposed to look for to say if that's a self-defense right emerging or not. Any other questions? And you have understood what retortion is. That was a diplomatic example we have given. And reprisal is actually when state responsibility law have to be devised, but it is not done. Instead, the state decides to punish the other state on its own. Until here, no other questions. You have one question. Yes, please.
I don't understand the relationship between proportionality damage and the...
Sinan has asked a question about what is the limit of self-defense. To what extent then a reaction can be given? The reaction must be proportionate with the damage given. So if the soldiers of another state are entering into state A is supposed to oust those soldiers. But if the state A suddenly decides to, for instance, shoot a nuclear weapon, the damage given is going to be so huge, then the question comes, was that proportionate? So this is, and the reaction in self-defense, perhaps it has to be proportionate, and proportionality is measured by the damage. The damage given, already given, or that may be caused. Because it can be estimated by the strategists, by seeing what kind of arsenal is being utilized, how many soldiers are entering, how many airplanes have started, and so on. Yes, please.
If state A invades state B, is it right to invade state B, or it's gonna be reprisal?
State A invades state B.
Yes, and state B win the battle.
Okay.
Again, they decide to invade state A territories.
Territorial integrity, sovereignty, they are basic elements in international law. State B is allowed to protect its territorial integrity, and it cannot harm territorial integrity of state A back. It must respect still the sovereignty, independence, and territorial integrity of state A. So there's no winning. It can only protect itself well. But if it's by winning, what you mean is, of course, acquiring some territory back from. It is not allowed.
What if there's a terrorist organization that's operating in state A and attacks state B? Can attack state A in terms of that?
So, state A attacks state B because of a terrorist organization in state B. Okay? Now, what we understand from sovereignty is absolute control. So state B is expected to have full control of its entire agents and territory. Still, this picture reminds us of
Libya.
in which year? 2001. This was the picture, and I was about to come to that point actually. Now you have learned what self-defense is. After 9/11, terror has entered into the literature. Preemption has also entered into the literature. Now we can define what self-defense is. If one of those three or some of them are attacked, then the state becomes the victim and the state can react back. Then it is self-defense. It is a right. It is purely legitimate and legal. Can you please tell me what preemption is?
If a state has a threat perception that it can be attacked, then it attacks first to destroy the military means of its perceived enemy.
Good. Is there anything you want to add to this?
So what's the difference between preemptive self-defense and security self-defense?
Wait. Preemption is not a legal term. In the legal literature, preemption does not exist.
But still they use it, right?
It is used. In Afghanistan case, that was the thing. And this, after what has happened in 9/11, that was a product of globalization, of course. The entire world becomes a huge village, and accessibility increases. Communication, transportation, and mobilization, they all got easy. And therefore, it was not only civilians moving around, it was not only investment and capital moving around, it was also crimes, criminals, terror moving around. And as a result, by 9/11, the United States was hit. And what we have heard from the US administration is that that was Al-Qaeda behind 9/11. Al-Qaeda, as a terrorist organization, is backed by Afghanistan, by the Taliban regime. Therefore, USA said they're going to remove that terrorist regime so that people of Afghanistan are going to be freed, first of all. Secondly, this is preemption. They already know that this regime supports terrorists. This regime is terrorizing the world, before they hit other states and US once again, US should take preventive measures. Therefore, they have coined preemption as a version of self-defense. So it exists now in history, preemption, but among the legal treaties, we do not come across with such a concept. Therefore, its legality, its legitimacy comes under scrutiny. If it's legal or not, if it's legitimate or not, is a huge question mark. It is debated in the literature.
I was going to ask what you could say about the invasion of Iraq.
Do you think Iraq has...
Actually, it's better if I mention it under another title. Good point, I'll come to that. I'll just keep it for a while, all right? Let me just talk about United Nations Security Council for a while. In the very beginning, we have said that the mandate of United Nations mainly is to maintain peace and security. So what is peace? What is security? Are questions, first of all. Secondly, it has 6 main organs. One of them is the United Nations Security Council. This council is established in order to maintain peace and security. Do you agree? Okay. This is the only UN branch that is authorized to use force under certain conditions. It can decide to use force when it sees threats against peace and security. So this is what is written in the United Nations UN Charter, all right? What does not exist in the Charter is the definition of threat against peace and security. What is a threat against international peace and security? We cannot say it on our own. We cannot define it on our own. What we can do is finding some evidence. Our evidence is only the former Security Council resolutions. For instance, Iraq has invaded Kuwait in 1990. And as a result, we have seen Security Council publishing a resolution. First of all, warning Iraq, and then setting some deadlines. And then Security Council has mobilized a coalition against Iraq, and the Iraqi army is also from Kuwait. So, Security Council makes its own definition of threats against peace and security through its resolutions. We have seen another resolution number 1972. That resolution is published against Gaddafi in Libya. What Gaddafi was doing, there was already a huge civil war in Libya, and Gaddafi was threatening his own people. Actually, he was using so harsh words, saying that, my children, I'll find you one by one in the cupboards that you're hiding, and I'll kill you one by one like insects. So that's what he was saying. So he was all the time inciting a civil war. And Security Council had decided to take an action against Gaddafi. And the coalition has entered. But a similar situation was also happening in Syria. And there, we do not come across with a Security Council resolution against Syria, right? So we can only tell what are threats against international peace and security through using the evidence provided by the Security Council, through the entire resolutions published by the UN, and perhaps also the unpublished ones. So when Security Council remained silent, when Security Council decided to define. you know what? This was easy to follow until 9/11. Until 9/11, what was happening was just like Iraq's invasion of Kuwait. So it was just a regular war. After 9/11, terror has entered into the literature, international terror, transnational terror. And this has created a huge gap and question mark. In this regard, Security Council has started publishing some resolutions, making some decisions targeting international terror. Targeting international terror, what Security Council has done is targeting certain terrorist suspects as individuals. And unfortunately, many acts of Security Council were full of errors, mistakes, wrong people were targeted, and so on. And because it's so confusing, we have to ask the question, why did it become so confusing for Security Council to target international terror? The answer is, this is really important what I'm telling you at the moment. There is no internationally agreed definition of terror. Terror itself, etymologically, we can answer the question, terrorizing someone or terror is, what does that mean?
Fearing.
Of course, spreading fear. However, in legal terms, what terror is a huge unknown. The lack of definition is because of political contradictions. What I mean is that Turkey and United States are having hard relations at the moment with each other. YPG in Syria is a freedom fighter for the US side, and they have made many efforts against Daesh terror in Syria. This is how US sees the issue. When we start to take a look from Turkish side, Turkish government claims that YPG is an organic particle of PKK terrorist organization. Or another example is Hamas from Palestine. Hamas is seen as a terrorist organization, we can simply say, for the Western world in a general way. And for the Eastern world, they are representatives, political representatives of Palestine. So, there is a famous saying, keep this in mind. One side's freedom fighter is the terrorist of the other one. One man's freedom fighter is the terrorist of the other one. This is why we don't have an internationally agreed definition of terror at the moment. When we take a closer look at the UN agreements, at the treaties, at declarations and so on, we never see a sentence defining what terror is, but what we see is definitions of terrorist activities. Activities are defined, like what terrorist hijacking is, or what kidnapping is, what mass killings mean, what terrorist bombing is. Activities are defined, but the concept is not defined. We have studied in this class international criminal law. And we have learned that there is also an international court. It is known as International Criminal Court. This court is liable to detain even the leaders, right? So we have an international system that can even punish the leaders that are actually immune against laws. However, because we don't have an internationally agreed definition of terror, we don't have an international court for terrorists. We don't have a world court of terrorism or terrorists. There's a huge gap over there. And at the moment, it is impossible to talk about what's happening in the Middle East without mentioning terrorist organizations. Or if you personally find my saying terrorist organizations wrong, then I can say violent non-state actors. Or armed non-state actors. There are numerous terrorist organizations, or there are numerous violent non-state actors or armed non-state actors in the Middle East. It is impossible to talk about what's happening in Iraq. It's impossible to talk about what's happening in Syria without using names of Daesh, without mentioning YPG, without mentioning Al-Nusra Front, without mentioning what else, Islamic Jihad, and so on. So there are non-state actors, they have their weapons, and they're controlling certain territories, and they're threatening people, they're killing people for their strategic aims. And this cannot be dealt at the moment by international law. Security Council is established for the protection of international peace and security. The thing is that it cannot fully function because of certain loopholes in international law. And those, from the very beginning, we have always emphasized that international law and international politics must intersect. So international law can produce a definition for terror if international politics allow. Otherwise, it's impossible. Could you follow everything related to terror and that gap? Do you have any questions? Yes, please.
If we have the Security Council responsible for maintaining peace and security, why do we have the right of self-defense then? Don't states trust fully on the Security Council?
Well, tell me, self-defense is an immediate reaction. Imagine your country is being occupied by another country. Then you make an application by the Security Council. Security Council gathers. They discuss the issue. Okay, they decide to take a reactive action. Then who is going to be in the coalition? States discuss it once again. They pick, your country is already lost. So this is also necessary. Self-defense must be a right over there for immediate protection of own rights, statehood rights. All right? Now, if you don't have, yes, please.
So we can also use self-defense against non-state actors, right?
Of course, sure. Because self-defense is related to protection of your sovereignty, independence, and territorial integrity. Of course, it's a right. The thing is that Security Council cannot unite and take action against certain groups. I mean, what's happening in Syria is something politically torn in between Russia and United States. There's a prominent Turkish international relations scholar, Deniz Ülke Arıboğan, and probably you have already heard that. While she's talking about terror, she says that terrorist organizations are just like a football in the football pitch. And all the players are the states. Whoever reaches the ball kicks it in order to score a goal. So, terrorist organizations are already in the field. Whoever approaches them uses them for their geopolitical aims, of course. They provide them either with money, financial support, or with guns and weapons, and so on. So, because all states are using terror, they refrain from defining terror because it is not for their advantage. That's the problem. Yes, please.
I was going to ask about this. What was the title? Was it about maintaining peace and security or humanitarian intervention?
Whatever. No, I'll come to that. Humanitarian intervention. Good point. Okay, we can move. You have another question?
Can you say the United Nations Security Council could not give a each actor, such as Russia and USA, use the terrorist organizations within Syria.
Must they have used that?
Yeah.
Of course, therefore.
It's because the Permanent Five could not agree on something, they could not fight together.
That's it. Of course, they have to unite. Whenever one of them vetoes the decision cannot be taken then. The resolution cannot be published.
And one more question, they gave a resolution about Gaddafi. Is because the Permanent Five agreed?
Yes.
Okay.
Yes. Now, the question was about humanitarian intervention. In our recent history, we have seen, I can start again with US invading Afghanistan in 2001. US invading Iraq in 2003. Okay, in the very beginning, in Afghanistan, terrorist organization is in Afghanistan, and the regime in Afghanistan, the Taliban regime, shelters Al-Qaeda. And that was the general picture. If you remember, Afghanistan, women are running around in their burqas, so human rights are massively violated. So there are human rights violations. There is no democracy. There is no freedom. So Afghanistan brings freedom to Afghanistan. United States brings democracy to Afghanistan. You're already smiling. United States stops human rights violations in Afghanistan, promotes human rights in Afghanistan. It brings an end to illegitimate Taliban regime. Now we're about to negotiate with the Taliban regime, by the way. So they're still there, no one's lost it. And Al-Qaeda terror is finalized. That's why this invasion has taken place. Later, in 2003, United States have invaded Iraq, right? Because who was there? The leader was? Saddam Hussein was there. And it was said that Saddam Hussein is developing their own nuclear explosives. Do you remember the pictures? I remember the pictures of certain lorries entering into certain buildings.
Yes,
And that was
being thrown.
it was what was happening later. Before the entire invasion, United States have published many pictures, satellite pictures and so on from Iraq, saying that Saddam Hussein is getting ready for a nuclear war. They're producing their own nuclear weapons. They have hid their nuclear weapons underneath the soil. So US is going to go there, oust Saddam regime, and prevent that nuclear war and bring democracy and freedom to Iraq and promote human rights. While US invades Iraq, is there a Security Council decision taken? It's a unilateral decision.
So is it somehow...
Wait a little bit. This is a unilateral decision. This is not an invasion that was authorized by the Security Council. What do you think then? At the moment you have learned the basic measures of legal system. So what US has done to Afghanistan can also be assessed as a use of force, which is illegitimate and illegal actually, because Security Council does not have a play. Well, US is not claiming that, okay, we're invading Iraq at the moment because there is nice oil over there. US says that what we're going to do in Iraq is a humanitarian intervention. In your question, you were asking me if Security Council was making a Security Council and humanitarian intervention are two words that they never come together. All right? If it's a humanitarian intervention, then it is unilateral. Then we don't come across with an authorization of the Security Council. Humanitarian intervention is not legally structured. It is not legally structured. This means we don't know the basis of humanitarian intervention. Okay, it is humanitarian. It is to free people. It is to bring freedom. It is to promote democracy, to bring democracy. It is to promote human rights. But you know what? If I sell you a pair of shoes, I cargo it to you. As a result of the shipment, you open the box and you find, instead of one proper pair, you find two left feet shoes. This is also a violation of rights. Then should US invade? Extreme example, of course not. The thing is that here we don't have a definition of what human rights violation is. Which human rights violations are going to be when reacted by the humanitarian intervention? Humanitarian intervention is, there is one state A and one state B. State B violates human rights of their own citizens. It doesn't do anything to state A, but state A starts a military action, a military campaign against state B on behalf of human rights. This is humanitarian intervention. And we have examples of that in our history, but its legitimacy is questionable. And its legality is, well, it doesn't have a legal infrastructure actually. With a better English, it's illegal actually. So it doesn't have a legal structure. Which human rights is definitely not defined. Unilateral Security Council does not have a say in it. And it is highly debatable because we can talk about unacceptable geopolitical goals. So human rights can be seen as an excuse for unacceptable geopolitical aims. Well, after 2003, there was a huge debate related to United Nations. If it has completely lost its legitimacy, no one asks for the authorization of the Security Council, then it has no use anymore. It doesn't have a say in international peace. Then why should we keep it? Is it really necessary? Should we establish a new world order? And if the answer is yes, then how? That was a huge debate. And as a result, a new formulation is found out. Here you have seen the problems of humanitarian intervention. In order to be able to deal with that, United Nations have coined something new, which is known as R2P, responsibility to protect. Responsibility to protect is an action, just like in here, state A and state B are there. State B violates human rights of their own citizens. Then what happens is not a unilateral action. This time, we look for a resolution from the Security Council. And in humanitarian intervention, we have said that legal structure is not there. Here we have a legal structure. Well, R2P takes place when human rights are violated. But which human rights violations? There are four conditions. First three are already known to you from Rome Statute. If there is a genocide, if there is, great. What else? It is not there in this list. But crimes of? Aggression is not there. What crimes?
Crimes against humanity.
Good. Crimes against humanity. The fourth one is not act of aggression. The fourth one here in our list is ethnic cleansing. So, responsibility to protect is devised by the Security Council, first of all. Secondly, it can only be devised if one of those crimes is being committed. And in humanitarian intervention is pure military attack. Here, under R2P, first of all, other remedies are tried, like diplomatic measures, political measures, economic measures, embargoes, barriers, and if none of them works, then it is possible to go for a military action. This military action is the last remedy. If all other remedies fail, then this can be devised. Of course, one of the most important pillars of R2P is a timely response. This means before it is so late. Yes. So sometimes, well, for the case of Libya, there are a couple of resolutions. First, Libyan leaders, Libyan government is called for taking certain measures. After they have failed, then R2P decision was given with resolution 1972. And as a result, by the way, Security Council does not have its own army, of course. Instead, voluntary states enter into the coalition. After the resolution is published, states are just telling, for instance, state A says that I can provide you with soldiers. State B can say that I can provide you with airplanes, but I don't want to lend my pilots, for instance. Or I'm giving you 5 fighter jets with its pilots, but another state should provide the explosives to be dropped, for instance. So this is how the coalition is formed. The charter never tells how the composition of that army is going to be. It is devised on a voluntary basis. Who is going to take place in that coalition is definitely not predetermined. So this is how it is devised. So there's a huge difference in between humanitarian intervention and R2P. There are use of force methods. This one, the humanitarian intervention, doesn't seem as a legitimate and legal usage. R2P is structured under United Nations. It has many defects in that as well. You can still discuss if the case in Libya, did it get better? Definitely, I agree. Yes, please.
Peace enforcement operations are on.
Let's not mention it because it's not use of force, okay? Let's keep it. Yes. 2011, since 2011. That was before, yes. Yes.
Can you tell the difference between genocide and ethnic cleansing?
Well, genocide, you have already studied what genocide is. It has many elements in that. In ethnic cleansing, the targeted group, for instance, it is not killing, it is not harming, but those people are being somehow deported from the land. That's also kind of ethnic cleansing. So this definition has many gaps in it. Once the gaps is filled, there's a necessity to upgrade the existing treaties. Instead, ethnic cleansing is devised. All right? Whose hand did I see? You were about to ask something? You? Yes. Okay, that was the same thing. What else? If you don't have any other questions, there is one last point I'm going to mention. Actually, what I'm about to mention is something that we're going to study under diplomatic law. The state is something abstract. The state is established by human beings, and the state is there to serve human beings. The main thing that we expect from our state is, the foremost service of the state is providing us with protection. So we live under certain rules, norms, and principles so that we don't harm, we don't get harmed. This is why the state is there. State is also there for other services, of course, but the most important service of the state is protection. It protects the territory, first of all. We have always mentioned territorial integrity to be protected. It protects the sovereignty. It protects independence. It protects its agents and its population. So that protection is, it seems as if it's limited to its own territory. But the citizens of that state are mobile beings. And even though they can leave the state, well, you know that you can become easily a migrant if you go abroad to study your master's degree, for instance, for your PhD, for an internship, to find a job. If you fall in love and with your partner you're leaving the country, you become a migrant. This is something optional. You opt for doing so. After you leave the country for your internship, for your relationship, whatever, you are still under the protection of your own country, all right? You're still under the umbrella of your country. If you become a migrant, I'm not talking about asylum seeking, I'm not talking about refugeeship. You become, do you know what the definition of migrant? You become a migrant if you opt for being a migrant, if you want to become a migrant. And you can still come back to your country. You want to try, you want to see if you can find a job in the United States. And if you fail, you can still come back. You want to see if you can find a degree in Netherlands. You try it, and you come back after you get your degree. You conduct a research. Or that was another example. You fall in love. Therefore, you opt for living with your partner in Norway. And then if it doesn't go well, then you can still come back. But if you become a refugee, that's something else. You never come back, okay? So a migrant is, you become migrant by volunteering it. And all migrants, all citizens of the country that are abroad are still under the protection umbrella of their state of origin. As long as you have your passport, you're under the protection of your state. State is the main protector of your human rights. Then comes the other steps. You can say that, well, European Court of Human Rights. European Court of Human Rights does not protect you on a regular basis. European Court of Human Rights protects you if your state fails to protect you. Then that can be something. Yes?
What if you are a migrant and your state no longer exists?
Then you don't have that. Then if it doesn't exist, how can that protect you? Now, what I'm about to mention is that the state can still protect its citizens when the citizens are abroad. how it happens. For instance, it can say that the country is not secure anymore. We call our citizens to leave this country as soon as possible. This kind of protection, it informs, it provides knowledge. Or under certain immediate emergencies, the state can decide to open its consulates or embassy buildings to its own nationals for a shelter. This is also a kind of protection. There are many other protection methods. The thing is that we're going to study those protection methods under diplomatic law, and this is not a kind of use of force. Downgrading diplomatic relations is a kind of use of force. But this one is not. Could you follow everything under this chapter? Do you come up with any kind of questions? What you have learned, what you should not forget is that, first of all, use of force is completely prohibited by the UN Charter. And threatening other states by use of force is also prohibited by the UN Charter. There is another source, in addition to UN Charter 45. This is known as the Declaration of 1970. According to that declaration, we have also found out that terrorism is also a violation of use of force prohibition. And reprisals are definitely not allowed. And threatening is still not allowed. Use of force is not allowed, and so on. Security Council is the only authorized international organization to use force under certain conditions because its mandate is protection of international peace and security. Security Council is completely inactive if there is no threat against peace and security, and it doesn't have its own army. It is completed through volunteers, that's true. Terror is a huge gap in this international system. Terror itself is use of force. However, international system remains weak to deal with terror because of the lack of definition. There is no international agreed definition of terror. What we find in international agreements is only definitions of terrorist activities like hijacking, kidnapping, mass killings, terrorist bombings are mentioned in those papers. But what terror is not defined. The reason is that because all states are somehow utilizing from terror, and definition of terror is some better not. Terrorism is not defined because of political reasons. One man's freedom fighter is another man's terrorist. We have given the example of YPG in between United States and Turkey. We have given the example of Hamas in between Western world and Eastern world. So you can also tell me why there is no definition of terror. We have visited the right of self-defense, and we have said that self-defense is legitimate if the state is victimized. And the state is victimized under three conditions. If its territorial integrity is targeted, if its independence is targeted, if its sovereignty is targeted. Those three. And there is also another word that was coined by George W. Bush, preemptive strikes, preemption. It was reflected as a kind of self-defense. However, it does not match with the definition of self-defense. And we have also discussed about humanitarian intervention versus responsibility to protect. Humanitarian intervention is unilateral. Humanitarian intervention does not require any kind of UN Security Council authorization. Humanitarian intervention's excuse is always protecting and promoting human rights, but it is highly debated that it is actually sheltering a huge number of unacceptable geopolitical goals in it. So it's an excuse, human rights protection. However, states are trying to gain something else through that. Responsibility to protect is fully structured under Security Council. By the way, it's not problem-free. It has also many problems, but at the moment we don't need to discuss them to depth. Security Council resolution is necessary, and what human rights violations are also defined. Only under 4 kinds of violations responsibility to protect can take place. Humanitarian interventions, pure military action. Responsibility to protect can include economic sanctions, political sanctions, diplomatic sphering. And if they do not work, then military action can be taken. In between, humanitarian aid can be carried as well, if that also it also adds something. And humanitarian aid does not mean only bringing toys to children. Humanitarian aid is also training state officials. Like if the police is all the time violating human rights, then the police force of that state can be trained by the United Nations not to violate human rights. Okay? So this can also be provided in between. So that's the general outline of use of force. Any questions? Yes.
First of all, there is to be armed attack, right? When
Under
there
what
is
condition?
self-defense.
Yes.
Without armed attack, not possible.
We can't talk about any kind of territorial integrity violation, for instance.
What if in case of cyber war, there is no armed attack, but there is
Cyber law is also a very specific branch of international law, and at the moment it has been happening actually in between United States and China. Or US elections were somehow manipulated by Russia, but international law somehow remains weak in terms of cyber war. But that's also kind of attack, that's true, and that's an attack against sovereignty, that's also true. Therefore, it also requires self-defense. The question is how? Okay? This is not well defined at the moment.